Hello, my name is Jacqueline Ladone. I am an attorney at Legal Services of Greater Miami. In this video, I will provide you with information about mediation in eviction cases. This informational video is intended for tenants in Miami-Dade County. If you have properly filed an answer and deposited your rent into the court registry, or filed a motion to determine rent, the court may set the case for mediation. Mediation is a process where both parties come together to see if they can resolve the case. You will receive a notice stating the time, date, and place of the mediation. If you do not go to the mediation, the court could enter a judgment against you, meaning you will lose the case and will ultimately be evicted. If you work out an agreement during mediation, it is written up on the court's form and the judge signs it. The eviction case will be dismissed. If you violate the agreement, the landlord can file an Affidavit of Non-Compliance and ask the court to evict you. The court form says you do not have the right to be notified of the landlord asking the court to evict you. You should ask the mediator to change the form so that you get notice and a right to a hearing before the judge tries to evict you. If you violate the agreement in any way, the landlord can seek a judgment against you and have you evicted. Oftentimes, the mediator will pressure tenants to enter into an agreement with the landlord. It is important that you not be pressured to sign an agreement, such as a payment plan that you cannot afford. If you violate the agreement and the landlord files a motion against you, the landlord may obtain a final judgment against you. Once the final judgment is entered against you, a writ of possession, sometimes called a 24-hour notice, will be issued. A writ of possession will then be posted on your door. Once the writ of possession is posted on your door, the sheriff can come back to your door the next day and remove you and your family along with your belongings from your home and change your locks. The sheriff is not responsible for any damage to your property. If you do not come to an agreement at mediation, you should continue to deposit your rent into the court registry at the beginning of each month. If you do not resolve your case at mediation, some judges will want to conduct a hearing right away that very same day. Other judges will set the case for hearing at a later time. You should receive notice from the court as to the time, date, and place for the hearing. If you do not go to the hearing, the judge will most likely enter an order against you and you will be evicted from your home. Final hearing or trials are conducted very quickly. Be respectful of the judge. Do not ever interrupt the judge. At the hearing, you should bring all evidence you have to support your case. For example, if you have paid your rent, you should bring all the rent receipts you have. If you have witnesses to support your argument, you should bring them to court. If you have raised the defense of bad conditions, you should bring in photos or any other witnesses that you have. At the end of the hearing, the judge will most likely enter an order. Review the order immediately. If you do not understand any of the terms, ask the judge to explain the terms of the order. If the case is dismissed, that means that the eviction case against you is over. However, if a final judgment is entered, that means you have lost the eviction case and a writ of possession will soon be posted on your door. We hope you have found this informational video useful. For more information about the eviction process, please go to our website www.lsgmi.org and go to the Getting Help tab for more information. Thank you.